Good morning. My name is John Rogers, and I'm Environmental Manager of the Division of Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining as a hearing examiner in this proceeding. Today is Wednesday, November 20th, 2024, and this is a time and place for the hearing examiner proceeding for docket number 2024-070, cause number 132-64. In a matter of the request for agency action of Vintage USA Inc. for our order pulling interests, including compulsory pulling of the interests of certain non-consenting owners in the Conopatch, Utah 5-19 3-1-30-31-7H well, in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations comprised of all sections 30 and 31, Township 3 South, Range 1 West, Uinta Special Meridian, Duchesne County, Utah. We are holding this hearing with the anchor position in the Department of Natural Resources building in Salt Lake City, Utah. We also will be hearing testimony and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank all those who have been involved with those proceedings and allowing them to go forth remotely. Before we begin, are there any members of the public or respondents present, either here or online? Anyone online?
There's nobody online.
Okay.
Nobody from the public.
Okay. Take note that there are no respondents here in the room today or online. We'll now take appearance of counsel at this time.
Fred McDonald of Counsel with Lear & Lear on behalf of Petitioner of Vintage USA Inc.
Division.
Gordon Rowe, Assistant Attorney General for the division.
Okay. And my counsel is Emily McKay of the Attorney General's office. Some procedural items before we begin. I received declarations for this matter from Mr. Ashley Ellison, Senior Land Negotiator for Ovintiv USA, and Mr. Christopher Wall, Reservoir Engineer Advisor for Ovintiv. I read both of the declarations before this hearing. Both these witnesses have been accepted as witnesses in the past. Does the division have any objections to these declarations this time, or are these individuals being qualified as expert witnesses?
No objection from the division.
Okay. They are recognized as expert witnesses in their particular field of study and work for this matter. Mr. McDonald, are these witnesses present here today?
They are, Mr. Rogers.
Okay. Can we now swear them in?
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Yes.
Okay. All right, we will accept them as expert witnesses at this time. We'll now turn the time over to Mr. McDonald for his presentation.
Thank you, Mr. Rogers. And just for the record, Mr. Ellison is being recognized as an expert in petroleum land management, and Mr. Wall is being recognized as an expert in petroleum engineering and reservoir engineering for purposes of this cause. The board, and by designation, Mr. Rogers as the hearing examiner, have jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations at R649-28A and R649-2-9A. A copy of the request for agency action was mailed certified mail to the known parties sought to be compulsory pooled and mailed regular mail to all the production interest owners within the drilling unit at issue at their last addresses disclosed by the relevant realty records and Ovintiv's internal records, and also was sent to the Ute Indian Tribe, Ute Distribution Corporation, and the Bureau of Indian Affairs, Uinta and Ouray Agency, and the Vernal Field Office of the Bureau of Land Management, which serves as the technical advisor to the BIA due to the tribal and allotted mineral ownership. Notice was also sent to the Department of Wildlife Resources and the Division of Forestry, Fire, and State Lands due to the state mineral ownership within the drilling unit. Exhibit 23, as supplemented on Monday, reflects the status of the certified mailings to the known parties to be compulsory pooled with valid addresses. In addition, notice of the filing of the request and of this hearing was also duly published in the Salt Lake Tribune on October 27, 2024, the Uinta Basin Standard on October 30th, 2024, and in the Deseret News November 1st, 2024. On November 12, 2024, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request, and no other objections or responses to the request were timely filed. To summarize this case, this cause involves the compulsory pooling of the drilling unit established for Lower Green River Wasatch production, comprised of the entirety of sections 30 and 31 of Township 3 South, Range 1 West, USM. That drilling unit was established by the board's order on cause number 139-134. It's shown on Exhibit 3, which is shown on the PowerPoint. As shown on Exhibit 4, Sections 30 and 31 are irregular sections comprised of lots along the west half of each section, and the remainder of quarter sections. As a consequence, the drilling unit is comprised of 1,261.84 acres. Ovintiv is the majority working interest owner as shown on revised Exhibit 7 and is outlined in paragraph 11 of Mr. Ellison's declaration. A true and correct copy of the 139-134 order was submitted as Exhibit 2. In accordance with the 139-134 order, new field drilled and Ovintiv now operates the Kona Patch 7H well at issue here with first production on May 8, 2018. All is outlined in paragraph 3 of the request and paragraph 10 of Mr. Ellison's declaration. It is the only well currently on the drilling unit and is reflected on Exhibit 5. That is the general location of that well. There are 4 specific parties to be compulsory pooled and declared as non-consenting owners in the Kona Patch 7H well. These are Becky Lawson, Paul Jensen, Laura Little Wilson, and Julie Little Click. As evidenced by Exhibits 12 through 17 and is addressed in paragraphs 15 through 18 of Mr. Ellison's declaration, the requisite notices of opportunity to participate in the Kona Patch 7H well were provided to Mr. Jensen, Ms. Wilson, and Ms. Click, but none formally and timely responded. They all did receive that notice. As evidenced by Exhibits 11, 15 through 17, and replacement Exhibit 18, and is addressed in paragraph 14 of Mr. Ellison's declaration, Ms. Lawson was also sent the requisite notice of opportunity to participate in that well to her last known address, but it was returned to Ovintiv as undeliverable. Pursuant to the board's order entered on October 15, 2024, she was also provided her notice by publication in the Uinta Basin Standard on October 23rd and October 30th, 2024, but she too failed to formally and timely respond to the notice. As addressed in paragraph 13 of Mr. Ellison's declaration, subsequent to the filing of the request and the exhibits, Ovintiv discovered that the estate of William Homer Edwards was probated in Davis County, Utah, commencing in 2007, with Dale R. Edwards appointed as personal representative of that estate. Mr. Edwards, in that capacity, recently ratified a lease in favor of Ovintiv, which is binding upon the interest of Dale Russell Edwards, Billy Gay Reese, and Don Homer Edwards, who were parties named in the request to be compulsory pooled and declared as non-consenting owners in the Kona Patch well. As a consequence, Ovintiv now moves to amend the request to eliminate those 3 parties, as well as any other party claiming by, through, or under the estate of William H. Edwards. And Exhibits 8 through 10 will not be submitted for admission into evidence. Revised Exhibit 7 does reflect the previously unleased gross working interest of those 3 parties as now being credited to Ovintiv, and conversely, the reduction of the gross working interest of the parties to be compulsory pooled. In addition, although Ovintiv believes it has leased all such successors and voluntarily pooled their interests pursuant to the pooling clauses contained in the leases, except as to any party specifically identified in the request to claim through one of these estates, with the exception of the estate of William H. Edwards, as I just addressed. There may be additional parties claiming by, through, or under certain decedents, as identified in paragraph 19 of Mr. Ellison's declaration. These estates may not have been probated in Utah or are incomplete in distribution of the subject mineral interests. Pursuant to the board's order entered on October 15, 2024, the requisite notice of opportunity to participate was provided to these unknown parties by publication in the Uinta Basin Standard on October 23rd and October 30th, 2024. No responses to those public notice were ever received. Replacement Exhibit 18 in this cause is a true and correct copy of the affidavit of the notice of publication of the notice of opportunity to participate received from the Uinta Basin Standard. As evidenced by Exhibit 19 and is addressed in paragraph 24 of Mr. Ellison's declaration, and as shown on Exhibit 19B on the PowerPoint, The average weighted fee landowner's royalty in the drilling unit as of the date of spud of Conopatch 7H well is 19.160519%. As addressed in paragraph 25 of Mr. Ellison's declaration, the parties shown on the certificate of service filed in this cause are all of the production interest owners in the drilling unit. Their names and addresses were derived from a title opinion dated effective as of November 17, 2023, as supplemented by a record search by Ovintiv's contract landmen and Ovintiv's internal records. As the record will reflect, none of these parties identified in the request as being compulsory pooled and declared as non-consenting owners in this cause timely filed a response or have made an appearance today. Consequently, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, Ovintiv now moves to enter an order of default against them, and I ask that the hearing examiner rule on that motion.
Division.
Just so I'm clear, the 30 days to respond from some of those parties hadn't ran at the time of the RAA, but has since ran and no.
That is correct.
Okay, then no objection.
Vote second.
Thank you. Motion granted. As evidenced by Exhibit 20 and as outlined in paragraph 5 of Mr. Wall's declaration, the actual costs of the Conopatch 7H well were reasonable and necessarily incurred and were within reasonable variance of the AFE that was filed as an exhibit. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment cost for the Conopatch 7H well is $75,000. Finally, on exhibits 21 and 22, in paragraph 7 and 8 of Mr. Wall's declaration, the risks are outlined which Ovintiv assumed at the time of the spud of the Conopatch 7H well. With that, I'll now commence my examination of Mr. Ellison. Mr. Ellison, would you please state your name and business address for the record?
Yes, sir. My name is Ashley Ellison. Business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas 77380.
Would you please state your position with Ovintiv and its relation to the drilling unit and the well at issue today?
I'm a senior land negotiator with responsibility over this drilling unit, amongst others.
All right. Would you please state for the record now the corporate and bonding status of Ovintiv?
Ovintiv is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger with Ovintiv Production, Inc.
Mr. Ellison, would you confirm for the record that exhibits 3 through 6, revised exhibit 7, exhibits 11 through 17 and 19 were prepared by you or Ovintiv personnel or contractors with your review and input?
They were, sir.
You also confirm for the record that replacement exhibit 18 is an official business record of Ovintiv?
That is correct.
All right, Mr. Ellison, have you reviewed your declarations and can you confirm for the record all the statements made therein are true and correct? Or at this time, would you state if any other modifications are required?
They are true and correct, and no further modifications are needed.
All right, with regard to the joint operating agreement, is your expert opinion as a petroleum land management expert that the terms and conditions of that operating agreement submitted as Exhibit 17 are fair, reasonable, and consistent with those commonly accepted by industry, and in particular the Uinta Basin with respect to horizontal well operations?
That is correct.
All right, Mr. Rogers, that concludes my examination of Mr. Ellison. If you or the division have questions at this time.
Okay, thank you. Division?
Just for curiosity's sake, Exhibit 20 shows a little over $38,000 for consent decree payment. Would you mind explaining what that is?
You may want to wait until Mr. Wall's testimony, since that's his exhibit.
Well,
Okay.
thanks.
No
Nothing. Yes. No.
Okay, I got a question on Mr. Ellison's declaration. No, this is on the request for agency action on page 4. It says the subject well achieved 100% payout on October 31st, 2018. No other wells are located on the DSU. Well was spud in February of that year, February 6, 2018. So in a 9-month period, roughly, it reached payout.
Mr. Ellison?
Chris might know more about the economics of this well specifically. Unfortunately, I do not.
Can we ask Mr. Wall, or should we wait for him?
Yeah.
Okay.
Sorry, guys.
In that case, I have no more questions for Mr. Ellison. And so we'll continue on to your next business.
Thank you, Mr. Rogers. Mr. Wall, would you please state your name and business address for the record?
It's Christopher Wall, 4 Waterway Square Place Drive, Suite 100, Woodlands, Texas, 77380.
And what is your current position with Ovintiv, and how does it relate to this drilling unit and the well at issue?
Yes, I'm a reservoir engineering advisor for Ovintiv, working this DSU as well as others in the Uinta Basin.
All right, Mr. Wall, would you confirm for the record that exhibits 20 through 22 that were filed in this matter were prepared by you or Ovintiv personnel with your review and input?
Yes.
All right, would you also confirm for the record that you have read and can confirm that the statements made in your declaration are true and correct? Or if you have any modifications, would you please state them on the record at this time?
Yes. Everything is true and correct, and I do not have any modifications at this time.
All right, in your expert opinion as an expert in petroleum engineering and reservoir engineering, are the actual costs of the Kona Patch 7H well as reflected on Exhibit 20, which is shown on the power part, were they fair, reasonable, and necessarily incurred?
Yes.
All right, was the Kona Patch 7H well economically feasible to drill as that term is utilized in the 139-134 order?
Yes.
All right, and are the risks that were shown on exhibits 21 and 22, do they justify the imposition of a 300% risk assessment award and is fair and reasonable under the circumstances?
Yes.
All right, with that, Mr. Rogers, that concludes my examination. Mr. Wall, again, open it up for questions from you and the division.
Division?
I think this is the appropriate time to ask about that consent decree of about $38,000 and what that cost is representing.
So I'm not super well versed on the consent decree. However, my understanding of it is this is part of the penalty that the government assessed to Ovintiv, and that penalty was associated with certain facilities. The Kona Patch 7H facility fell underneath that penalty, and this is the portion of the 7H. This cost is a portion of that fee associated with the Kona Patch 7H.
Clean Air Act violations, or do you?
That's correct. Yes.
Okay, that helps. Any questions from you guys? Nothing else. Thank you.
Thank you, Mr. Rhodes. Back to my question a few minutes ago, I'll just review it again. It's on the request for agency action. The subject well achieved 100% payout on October 31st, 2018. The well was drilled in February of that year, so it paid out in basically 9 months. So what I'm wondering, given the 300% penalty, if it paid out that quickly, I am assuming it had very good production. And then has it reached a penalty stage now where it's not been paid out also?
In other words, the question, Mr. Wall, is the well achieved 300% payout yet?
Yeah, I can't answer that. I just don't know. I would say that 2018 was also a period of high oil prices, so that also helped to pay out.
Okay. My question is, given that possibly this had reached payout in the penalty phase, is there even to have these people? Won't they just go in as working owners at that time?
It will at that time.
But we don't know if they've reached that yet.
And plus, the fact is their production interest has been held in suspense. So the average weighted fee royalty has to be set to release that to them for that period of time through 300% payout.
Okay.
That's why we have to do it. And we also have to compulsory pool them in the drilling unit for any further development of that drilling unit.
Okay, I just want to make sure, because I was just, like I had Mr. Wall, it may have been very high oil prices at that time that accelerated that pace. Okay. Now I have no more questions for
All right, thank you, Mr. Rogers. That concludes our our presentation in chief. At this time, I would move for admission of exhibits 1 through 6, revised exhibit 7, exhibits 11 through 17, replacement exhibit 18, exhibits 19 through 22, and finally exhibit 23 is supplemented, as well as Mr. Ellison's and Mr. Wall's declarations.
So accepted. Goal division.
Division will waive its, case in chief and will recognize that it has submitted a notice of non-opposition and supports the request, brought by petitioner.
All right, well, Mr. Rowe, just trying to confirm, no objection to admission of the exhibits.
Oh, sorry. Yes. I'm a little rusty. No objection to the.
Okay, so accepted.
Thank you. I'm assuming that concludes the division's remarks too as well.
Yes.
At this point, then, we state that the statutory and regulatory requirements have been satisfied. The requested relief is fair, reasonable, and justified, and we ask that the hearing examiner recommend to the board that the request be approved as submitted. I want to thank you, Mr. Rogers, for your time and effort as the hearing examiner, and we also want to thank the DNR staff for making the virtual appearances possible today. And with that, concludes my comment.
And just from my understanding, you have no more.
Yeah. Yes. No objections. Support from the division. Appreciate everyone.
Okay. Okay. On closing, Mr. McDonald, would you like to do the admission for your exhibits, or is that?
That's what I've already
Is that done? Well, yeah, I have no more to add.
No.
Okay. So, having reviewed the request for agency action and all exhibits having considered the evidence presented here today, I find that Oventive has provided sufficient notice of opportunity to the non-consenting compulsory pooled owners, and that those owners have been identified in the RAA did not timely elect to participate in wells, and therefore it should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geological conditions present with this well, and find it would be appropriate to impose the requested non-consent penalty. I find that Oventive has met its burden of proof to show that they are entitled to force pooling of the named interest and other relief requested in a request for agency action. Mr. McDonald, will you please prepare an order?
Certainly, Mr. Rogers, and I'll make sure the council for both the division and yourself and the board are provide a copy of that before submission.
Okay, I then will present the findings and conclusions to the board next week at the board hearing. Well, not next week, it's actually in December. Okay. We got a little more time this month. Any other comments before we close?
None from me.
None from the division.
Emily, any? Okay. If there are no other comments or issues, we thank you for your participation and we'll adjourn this proceeding at this time. Thank you. Anyone need a break? Are we okay? I need some water. Is anyone nearby?
I can grab
You grab me one?
Well, this is my granddad's.
Julianne, do we make for Patty? I mean, does she have to write anything down or should we continue?
She's tracking the exhibits today.
Okay.
Now, let me know if I miss any, Julianne. I think I've got them all. Or Patty, when she gets back.
I like this new process of proffered testimony and appearing.
It makes it go a lot quicker, doesn't it?
Yeah.
All right, I'm still trying to get my PowerPoint up. Man, I think I've got issues again.
Let's face it. That's just decided to stop running off that face.
All right, so there's the PowerPoint.
Yeah.
And little window.
And we might be up there. It should be.
There we go. Perfect. Okay.
Okay, we'll get started. I won't get exit for a bit here, so sure. Patty will be back. You good to go, Matt?
We are good to go.
Okay.
Yeah, we're ready.
Good morning. My name is John Rogers, and I'm an environmental manager at the Utah Division of Oil, Gas, and Mining, and I've been appointed by the Board of Oil, Gas, and Mining to act as a hearing examiner in this proceeding. Today is Wednesday, November 20th, 2024, and this is the time and place for the hearing examiner proceeding for docket number 2024-071, cause number 13265. The matter of the request for agency action of Ovintiv USA Inc. for an order pulling interest, including the compulsory pulling of the interest of certain non-consenting orders in a null 13-10, 4-2-10-3-17H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations, comprised of all sections of 3 and 10, 4 south, range 2 west, Uinta Special Meridian, Duchesne County, Utah. We are holding this hearing with the anchor position in the Department of Natural Resources Building in Salt Lake City, Utah. We also will be hearing testimonies and presentations both in person and virtually, and proceedings will be broadcast on the internet. I wish to thank those who have been involved in this proceedings to go forth both remotely and in person. Before any members of the public or respondents present who wish to comment on this proceeding, I see none in this room. Matt, do we have any online?
No.
Okay. Let the record show there's no public present at this time. We'll take appearance of counsel at this time.
Fred McDonald of Counsel Lear and Lear on behalf of Petitioner Ovintiv USA Inc.
Gordon Rowe, Assistant Attorney General for the division.
My counsel is Emily McKay of the Attorney General's Office. Some procedural items at this time. I've received declarations for this matter from Mr. Ashley Ellison, Senior Land Ovintiv USA, and Mr. Christopher Wall, Reservoir Engineer Advisor for Ovintiv. I've reviewed both declarations before this hearing, and both these witnesses have been accepted as expert witnesses in the past hearings before this, before the division. Does the division have any objections to these declarations or these individuals being qualified as expert witnesses?
No objection.
Okay. They are recognized as expert witnesses in a particular field of study. Mr. Ellison in petroleum land management and Mr. Wall in reservoir engineering. Okay. Mr. McDonald, are these witnesses present here today? Can we
Yeah,
swear them
Mr.
in?
Rogers, and yes, I'd ask that they be sworn in at this time.
Please raise your right hand. Do you solemnly swear that the testimony you shall give hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, ma'am.
Yes.
Okay, thank you. We'll now turn it to Mr. McDonald for his presentation.
Thank you, Mr. Rogers. The board and by designation, Mr. Rogers is the hearing examiner, have jurisdiction over this matter pursuant to Utah Code annotated section 40-6-6.5 and the implementing regulations at R 649-2-8A and R 649-2-9A. A copy of the request for agency action was mailed certified mailing to the known parties sought to be compulsory pooled and mailed regular mail to all other production interest owners within the drilling unit at issue at their land addresses disclosed by the relevant relative records and Ovintiv's internal records. Exhibit 22 is supplemented on Monday, reflects the status of those certified mailings to the known compulsory pooled parties with valid addresses. In addition, notice of the filing of the request in this hearing was duly published in the Salt Lake Tribune on October 27, 2024, the Uinta Basin Standard on 30th, 2024, and in the Deseret News on November 1st, 2024. On November 12th, 2024, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request and no other objections or responses to the request were timely filed. In summary of this matter, this cause involves the compulsory pooling of the drilling unit established for Lower Green River Wasatch production, comprised of the entirety of sections 3 and 10 of 4 South, Range 2 West in Duchesne County, as shown on Exhibit 3. That's the location of the drilling unit. The drilling unit was established by the board's order entered in cause number 139-150. As shown on Exhibit 4, Section 3 is an irregular section comprised of lots along the north half, and the remainder in quarter sections. Section 10 is a regular section and therefore the drilling unit is comprised of 1,293.52 acres. As reflected on revised Exhibit 7, Oventive is the majority working interest owner in this drilling unit, and it's also as outlined in paragraph 11 of Mr. Ellison's declaration. A true and correct copy of the 139-150 order was submitted as Exhibit 2. In accordance with the 139-150 order, Oventive, or Newfield drilled and Oventive now operates the Knoll 17H well at issue here, which is shown in its general location on Exhibit 5, with first production on January 21st, 2019. All is outlined in paragraph 3 of the request and paragraph 10 of Mr. Ellison's declaration. It's the only well located on the drilling unit. As outlined in paragraph 6 of the request for agency action and paragraph 11 of Mr. Ellison's declaration, there are numerous other working interest owners in the drilling unit which have executed joint operating agreements, thereby voluntarily pooling their interests. There are 3 specific parties to be compulsory pooled and declared as non-consenting owners in the Knoll 17H well. These are Mary Ellen Slemaker-Benion, Colt Huber, and Tracy Lee Markham Sherrill. As evidenced by Exhibits 8, 9, and 14 through 16, and is addressed in paragraphs 13, 14, 16, and 17 of Mr. Ellison's declaration, the requisite notices of opportunity to participate in the Knoll well were provided to Ms. Benion and Mr. Huber, but neither formally or timely responded. As evidenced by Exhibits 12, 14 through 16, and replacement Exhibit 17, and is addressed in paragraph 16 of Mr. Ellison's declaration, Ms. Sherrill was also sent the requisite notice of opportunity to participate in the Knoll well to her last known address, but she refused delivery. Pursuant to the board's order entered in October 15, 2024, she also was provided her notice by publication in the Ueno Basin Standard on October 23rd and 30th, 2024, but she too failed to formally and timely respond. As addressed in paragraph 15 of Mr. Ellison's declaration, since the filing of the request, Kara Schultz and Courtney Yarber, who were parties named in the compulsory pooled and declared as non-consenting owners in the Knoll well, have executed leases in favor of Oventive. They consequently no longer need to be compulsory pooled, and Exhibits 10 and 11 will not be submitted for admission into evidence. Revised Exhibit 7 shows accounts for these changes in the gross working interest of Oventive and the compulsory pooled interests. Furthermore, as addressed in paragraph 11 of Mr. Ellison's declaration, subsequent to the filing of the request, 4X Holdings LLC, which was also named as a party to be compulsory pooled and declared as a non-consenting owner in this Knoll well, executed a joint operating agreement covering the drilling unit. Consequently, it also no longer needs to be compulsory pooled, and Exhibit 13 will not be submitted for admission into evidence. Revised Exhibit 7 also accounts for the changes due to 4X's execution of that joint operating agreement. In addition, although Oventive believes it has leased all such successors and voluntarily pooled their interests pursuant to the pooling clauses contained in their leases, except to any parties specifically identified in the request to claim through one of the estates, any party claiming by, through, or under certain decedents as identified in paragraph 18 of Mr. Ellison's declaration, whose estates have not been probated in Utah or incomplete in distribution of subject interests, were seeking to pool those parties' interests who are unknown at this time. Pursuant to the board's order entered on October 15, 2024, the requisite notice of opportunity to participate was provided to these unknown parties by publication in the Ueno Basin Standard, October 23rd and 30th, 2024. No responses were timely received to that publication. Replacement Exhibit 17 in this cause is a true and correct copy of the affidavit of publication of the notice of opportunity to participate received from the Ueno Basin Standard. As reflected on Exhibit 18, and I'm turning right to the last page, which is Exhibit 18G, in paragraph 23 of Mr. Ellison's declaration, the average weighted fee landowner's royalty as of the date of spud of the Knoll 17H well is 19.075488%. As outlined in paragraph 24, Mr. Ellison's declaration, the parties shown on the certificate of service filed in this cause are all of the production interest owners in the subject drilling unit. Their names and addresses were derived from a title opinion dated effective as of January 6, 2019, as supplemented by a record search by Ovina's contract landmen and Ovina's internal records. As the record will reflect, none of the parties identified in the request as being compulsory pooled and declared as non-consenting owners in this cause timely filed a response or have made an appearance today. Consequently, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, Ovina now moves to enter an order of default against them, and I ask the hearing examiner to rule on that motion at this time.
Division, do you have any?
No,
issue with
no
that?
objection to the motion for default.
So accepted.
Thank you, Mr. Rogers. As evidenced in Exhibit 19 and is outlined in paragraph 5 of Mr. Wall's declaration, the actual costs of the Knoll 17812 were reasonably and necessarily incurred and were within reasonable variance of the AFE that was submitted as part of the notices of opportunity to participate. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment cost for the Knoll 17H well is $75,000. Finally, as shown on exhibits 20 and 21 and as outlined in paragraph 7 and 8 of Mr. Wall's declaration, these are the risks that were assumed at the time of the spud of the Knoll 17H well. With that, I'll commence my examination of Mr. Ellison. Mr. Ellison, would you please state your name and business address for the record?
Yes, sir. My name is Ashley Ellison. Business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And what is your current position with Ovina, and how does it relate to the drilling unit and well at issue in this cause?
I'm a senior land negotiator with Ovintiv with responsibility over this drilling unit, amongst others.
All right, would you please state for the record the corporate and bonding status of Ovintiv?
Ovintiv is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. This is a successor by name change to Newfield Production Company and by merger of Ovintiv Production, Inc.
Mr. Ellison, would you please confirm for the record that exhibits 3 through 6, revised exhibits 7, exhibits 8, 9, 12, 14 through 16, and 18 were prepared by you or Ovintiv personnel or contractors with your review and input?
They were, sir.
And can you also confirm for the record that replacement exhibit 17 is an official business record of Ovintiv?
That is correct.
Would you also confirm for the record that you have read and confirmed all the statements made in your declaration are true and correct? Or please state at this time if any other further modifications are required.
They are correct and no modifications are required.
Okay, is it your expert opinion as a recognized expert in petroleum land management that the terms and conditions of the joint operating agreement submitted as exhibit 16 are fair and reasonable and consistent with those executed by the other working interest owners in this specific drilling unit and those commonly accepted by industry and in particular the Uinta Basin with respect to horizontal well operations?
That statement is correct.
Mr. Rogers, that concludes my examination. Mr. Ellison, opening up to questions from the division and yourself.
Okay.
Mr. Rowe, do you have any questions for this witness?
The division has identified a potential typographic error in where are we here?
Yes, first in the RAA. Sorry,
Okay.
with the division. Clear that up. Just in the API number,
Okay.
it's just it looks like a fat finger. It's just the 4 and the 3 are reversed.
On paragraph 4.
Yeah, it's actually when you pull it up on the website with this API, it pulls up the Iceman from
So it's the last 5 digits of the API number of 53402.
yes.
Okay, apologize for that.
Oh, yeah, it's fine.
Yeah,
Correctly
this is-
corrected
yeah,
then.
totally understand, but
Okay.
just want to make sure we get the right one, right?
Okay.
Other than that, nothing from the division.
Okay. Mr. McDonald, I should have maybe brought this up when you were talking about it. There was one individual that refused acceptance of the mailing.
Correct. Mr. Ellison's declaration address that. It's Tracy Sherrill.
Was there any, beyond that, was there any kind of verbal or kind of other contact tried to be made or?
Mr. Ellison, do you know if any
I don't know specifically. I do know that there are a few people in the basin that have inherited interest throughout the basin, and it's just tiny interests that sometimes people just get exhausted by all the paperwork that is necessary to own mineral rights in the basin. So they just stop wanting to talk to anybody. And our broker has made multiple attempts, kind attempts, just to address the situation. And sometimes people just stop accepting paperwork. Is the kind of the simple answer, unfortunately, for that.
I can add to that through the mailings that our office makes, Ms. Cheryl is in a lot of these drilling units, and this is typical of her.
This was kind of interested in that.
Yes.
Sure, it's a good question. Yeah.
Another question I have is on the, let's see here. On the original petition exhibits, number 7, Oventive's working interest owner amount was 99.55. It was amended to 92.67. We talked about that. What, maybe I missed, what was the cause of that change?
Sure. Yeah, I'm happy to answer it. 4X is a company that owns a large portion of that difference, I suppose. They've purchased mineral interest kind of throughout the basin. And since the time of the exhibit, they signed a JOA, and we added that interest into, or decreased our interest, and that is the kind of the main factor in that change.
So 4X bought mineral from Oventive?
No, they simply buy. They're a mineral buyer that goes around and buys minerals from just common day people, and they didn't buy the interest from that time frame. We simply they signed a JOA within that time frame, so we added them to the consenting non-op working interest line item.
Okay.
The bottom line is the compulsory pool interest shown on revised exhibit 7 is the current amount. It's very small.
Yeah.
But with the joint operating agreement now, they're all committed, so they don't have to be compulsory.
Okay. I know you went over that. I just want to.
Sure.
Do you have any questions? All right. Thank you.
Thank you, Mr. Rogers. With that, I'll commence my examination. Mr. Wall. Mr. Wall, would you please state your name and business address for the record?
Yes, my name is Christopher Wall. Business address 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas 77380.
And what is your current position with Oventive, and how does it relate to the drilling unit and well at issue in this cause?
I am a reservoir engineering advisor for Oventive with jurisdiction over this DSU as well as others in the Uinta Basin.
Would you please confirm for the record that exhibits 19 through 21 that were submitted in this cause were prepared by you or Oventive personnel with your review and input?
Yes.
All right. Would you also confirm for the record that you have read and can confirm all the statements made in your declaration are true and correct, or if any modifications are required, state them at this time?
Yes, and I do not require any modifications at this time.
All right. Is it your expert opinion as an expert, recognized expert in petroleum and reservoir engineering, that the actual costs of the Knoll 17H well reflected in Exhibit 19 were fair, reasonable, and necessarily incurred?
Yes.
Is it also your expert opinion that Knoll 17H well was economically feasible to drill, as that term is utilized in the 139-150 order?
Yes.
Finally, is it your expert opinion that the risks reflected on Exhibits 20 and 21 justify imposition of a 300% risk assessment award, and is it fair and reasonable under the circumstances?
Yes.
All right, with that, Mr. Rogers, that concludes my examination from Mr. Wall.
Okay. Division, any questions for this?
I'd just like to review the question for the record of the last matter regarding, in this matter, it's about $29,000 for the consent decree. Is that also related to the Clean Air Act violation penalties?
Yes, that's the portion of the fine that's associated with the 17H.
Great. You guys, that's all for the division.
Along those lines, I assume we'll see this probably in the other wells too, this consent decree.
I can't remember off the hand if it's gonna affect the Wyasket as well.
Well, maybe we can address that at the time.
Yeah, why don't we have that
Well, we'll
for the
get there.
next matter?
But anyway, I think it'd be good within, to just explain that is, so since it's new right now, and then maybe it will become old hat after a while, but it might be worth having that explained.
That's fine.
Okay.
Understand.
I have no question, Mr. Wall. Okay. Does that conclude your,
That's our presentation in chief. Mr. Rogers, at this time, I would move for admission of exhibits 1 through 6, revised exhibits 7, exhibits 8, 9, 12, 14 through 16, replacement exhibit 17, exhibits 18 through 21, and finally exhibit 22 is supplemented, as well as Mr. Ellison's and Mr. Wall's declarations.
division? Okay.
No objections.
Okay, so accepted.
Thank you. I'll just reserve closing remarks if the division has any remarks at this time.
Okay. The division filed a response of notice of non-opposition to this agency action on November 12th, 2024. Therefore, it's my understanding the division has no objection to this request for agency action, but reserve the right to respond as evidence in cross-examination of the proceedings. So we'll now turn the time over to the division to Mr. Rowe for their presentation.
We'll waive our case in chief and renew our non-opposition.
Okay. We'll now move to closing statements. We'll start with Mr. McDonald.
Thank you, Mr. Rogers. With that, again, the statutory and regulatory requirements have been satisfied. We believe that the requested relief is fair, reasonable, and justified, and we ask that you make the recommendation to the board that the request for agency action be approved as submitted, with the amendments of the parties, as I mentioned initially. I also want to thank you again for your time and efforts with this matter, and also the DNR staff for making the virtual appearances possible. With that, that concludes our presentation.
Any more to add, Mr. Rowe?
Nothing. Thank
Okay,
you.
thank you.
Thank you, everyone.
Okay, we've already moved for your exhibits being accepted. And so we will move along here, and having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find that Oventive has provided sufficient notice of opportunity to the non-consenting compulsory pooled owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells, and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified, given the economic and geological conditions present with this well, and find it would be appropriate to impose that requested non-consent penalty. I find that Oventive has met its burden of proof to show that they are entitled to the forced pulling of the named interest and other relief requested in the request for agency action. Mr. McDonald, will you please prepare the order?
I will, Ms. Rogers, and I'll make sure it's submitted to both the divisions and your council and the board's council for review.
Okay. I then will present the findings and conclusions to the board in December at their next board meeting. Any other comments before we close?
No.
Okay. No other comments or issues? We thank you for your participation, and we'll adjourn this proceeding at this time. Okay. Okay. Anyone need a break? Okay, we'll move along.
Let me get this one set up. I'm beginning. Yep. Hit the chair.
Oh.
The chair.
Just hit stop sharing and then
Back
to,
to,
yeah, to there. For some reason, caught in the loop.
This one, same error I had before,
Let's see, so stop sharing again.
right?
Go into the share. Go into share.
This,
And then go up. Oh. Huh.
window,
Sorry, it's
Yeah.
cold.
Like,
Beggars can't be choosers.
let's see what it says.
Yeah.
Sorry, an error has occurred when screen sharing. Let's try it again.
all right, let me close this out and try it again.
Okay.
I said, doing that. Yeah. Close it out again. All right, so then get that back up again. Get the matter over. Okay, then hit slideshow.
Yeah. Oh, that's okay. No, so yeah, so exit out of it. So hit the escape and then go to setup slideshow. You had already done that before, but you have to do it every time. So yeah, and then just do that.
Get in there.
Yeah,
Now hit start, right?
you got it.
Share.
You do one with all. There it is.
Okay. Okay.
We have sometimes entertaining people. Yeah.
Bring whenever you are, Mr. Rogers.
You good to go, Matt?
We are good to go. Yes. Thank you.
Good morning. My name is John Rogers. I'm an environmental manager at the Utah Division of Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining as a hearing examiner in this proceeding. Today is Wednesday, November 20th, 2024, and this is the time and place for the hearing examiner proceeding for docket number 2024-72, cause number 472-04, in a matter of the request for agency action of Ovintiv USA Inc. or order pulling interest, including compulsory pulling of the interest of certain non-consenting owners in the Wyasket, Utah 313-12, 3-1-12-1-47H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Formation, comprised of all the sections 1 and 12, Township 3 South, Range 1 West, Uinta Special Meridian, Uinta County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resource Building in Salt Lake City, Utah. We also will be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank all those who have allowed these proceedings to go forth both remotely and in person. Before we begin, are there any members of the public or respondents present who wish to comment on these proceedings? Seeing none in this room, Matt, is there any online?
No.
Okay, thank you. Let the record show no public respondents are present. We'll take appearance at council at this time.
From McDonald of Counsel with Lear and Lear on behalf of petitioner Ovintiv USA Inc.
Gordon Rowe, Assistant Attorney General for the division.
My counsel is Emily McKay of the Attorney General's office. I have received declarations for this matter from Mr. David Dale, Manager, Rockies Land for Ovintiv USA Inc., and Mr. Christopher Wall, Reservoir Engineer Advisor for Ovintiv. I have reviewed both declarations before this hearing. Both these witnesses have been accepted as expert witnesses for past hearings. Does the division have any objections to these declarations or to these individuals being qualified as expert witnesses?
No objection.
Okay. They are recognized as experts in their particular field of study and work for this matter. Mr. McDonald, are these witnesses present today?
They are Mr. Rogers, and just for the record again, Mr. Dale will be recognized as an expert in petroleum land management, and Mr. Wall will be recognized as an expert in petroleum engineering, reservoir engineering for first cause. I'd ask that they be sworn in at this time.
Please raise your right hand. Now, do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Yes.
Okay, thank you. We'll now proceed with Mr. McDonald for his presentation.
Thank you, Mr. Rogers. The board and by designation, Mr. Rogers is the hearing examiner, have jurisdiction over this matter pursuant to Utah Code annotated section 40-6-6.5 and the implementing regulations at R 649-2-8A and R 649-2-9A. Copy of the request for agency action was mailed certified mail to the known parties sought to be compulsory pooled and mailed regular mail to all other production interest owners within the drilling unit at issue at their last addresses disclosed by the relevant realty records and Oventive's internal records. It was also mailed to the Ute Indian Tribe, the Ute Distribution Corporation, the Bureau of Indian Affairs, Uinta and Ouray Agency, and the Vernal Field Office of the Bureau of Land Management, who serves as the technical advisor to the BIA due to the tribal and allotted mineral ownership in the drilling unit. Exhibit 20, as supplemented on Monday, reflects the status of the certified mailings to the known compulsory pool parties with valid addresses. In addition, the notice of the filing of the request and of this hearing was also duly published in the Salt Lake Tribune on October 27, 2024, the Uinta Basin Standard and Vernal Express on October 30th, 2024, and in the Deseret News on November 1st, 2022. On November 12, 2024, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request, and no other objections or responses to the request were timely filed. To summarize this matter, this cause involves the compulsory pooling of the drilling unit established for Lower Green River Wasatch production, comprised of the entirety of sections 1 and 12 of Township 3 South, Range 1 West, Uinta Special Meridian in Uinta County. That's reflected on Exhibit 3, shown on the PowerPoint right now. The drilling unit was established by the board's order entered in cause number 139-134. As shown on Exhibit 7, Oventive is by far the majority working interest owner, and this is also outlined in Mr. Dale's declaration in paragraph 10. As shown on Exhibit 4, Section 1 is an irregular section comprised of lots along the north half, and the rest in quarter sections. Section 12 is a regular section. Therefore, the drilling unit is comprised of 1,279.28 acres. A true and correct copy of the 139-134 order was submitted as Exhibit 2 in this matter. In accordance with that order, Newfield drilled and Oventive now operates the Wyasket 47H well at issue here. It's shown on Exhibit 5 in its general location. With its first production on November 29, 2018, all is outlined in paragraph 3 of the request and paragraph 9 of Mr. Dale's declaration. It's the only well located on the drilling unit. As outlined in paragraph 6 of the request for agency action and paragraph 10 of Mr. Dale's declaration, one other working interest owner in this drilling unit, Pool Creek Investments LLC, has executed a joint operating agreement naming Oventive as operator and thereby voluntarily pooling its interest. Excuse me. There are 4 specific parties to be compulsory pooled and declared as non-consenting owners in the Wyasket 47H well. These are Winnette E. Poliviayama, I believe that's how you pronounce it, Teresa J. Sirlwap, Connie L. Smith, and Uinta County. As evidenced by Exhibits 8, 10, 11 through 14, and is addressed in paragraphs 12 and 14 through 16 of Mr. Dale's declaration, the requisite notices of opportunity to participate in the Wyasket 47H well were provided to the 3 parties other than Ms. Sirlwap, Ms. Poliviayama, and Ms. Poliviayama and Ms. Smith did not formally and timely respond, while Uinta County did respond indicating a lease, but no lease has been executed today. As of evidenced by Exhibits 9, 12 through 14, and Replacement Exhibit 15, and is also addressed in paragraph 13 of Mr. Dale's declaration, Ms. Sarah Wap was also sent the requisite notice of opportunity to participate in the Wyasket well to her last known address, but it was returned to Oventive as undeliverable. Pursuant to the board's order entered on October 15, 2024, she was also provided her notice by publication in the Vernal Express on October 23rd and 30th, 2024, but she too failed to formally and timely respond. As addressed in paragraphs 17 and 18 of Mr. Dale's declaration, Ben Vigil and Bohemia Canapatch appear of record as still owning or potentially claiming ownership of an interest in the drilling unit. However, Ovintiv has confirmed both parties are deceased. Despite diligent efforts, Ovintiv has been unable to determine the heirs or devisees of Ben Vigil to provide the requisite notices of opportunity to participate in the Wyasket well to them. In addition, although Ovintiv believes it has leased all successors and voluntarily pooled their interests pursuant to the pooling clauses contained in their leases, except as to Uinta County, there may be additional parties claiming by through or under Bohemia Canapatch's estate. Neither Mr. Vigil nor Mr. Canapatch's estates have been probated in Utah. Pursuant to the board's order entered in October 15th, 2024, the requisite notices of opportunity to participate was provided to any party claiming by through or under these two decedents' estates not already leased or already participating in the Wyasket well by publication in the Vernal Express on October 23rd and 30th, 2024. No responses to those published notices were received. Replacement Exhibit 15 in this cause is a true and correct copy of the affidavit of publication of the notices of opportunity to participate received from the Vernal Express. As reflected on Exhibit 16 and in paragraph 23 of Mr. Dale's declaration, the average weighted fee landowner's royalty as of the date of spud of the Wyasket well is 17.824565%. As outlined in paragraph 24 of Mr. Dale's declaration, the parties shown on the certificate of service in this cause are all the production interest owners in the drilling unit. Their names and addresses were derived from a title opinion dated effective as of October 31st, 2017, as supplemented by a record search by Ovintiv's contract landmen and Ovintiv's internal records. As the record will reflect, none of the parties identified in the request as being compulsory pooled and declared as non-consenting owners in this cause timely filed a response or have made an appearance today. As a consequence, pursuant to Utah Admin Code R 641-104-150 and R 641-108-400, Ovintiv now moves to enter an order of default against them, and we ask that the hearing examiner rule on that motion at this time.
No objection.
Okay, so accepted.
Thank you. As evidenced by Exhibit 17 and as outlined in paragraph 5 of Mr. Wall's declaration, the actual costs of the Wyasket well were reasonably and necessarily incurred and were within reasonable variances of the AFE that was submitted as part of the notices of opportunity to participate. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment cost for the Wyasket well is $75,000. And finally, as shown on Exhibits 18 and 19 and is addressed in paragraph 7 and 8 of Mr. Wall's declaration, these are the risks that were assumed at the time of the spud of the Wyasket well. With that, I'll commence my examination of Mr. Dale. Mr. Dale, would you please state your name and business address for the record?
Yes, David Dale, 4 Waterway Square Place, Suite 100, Woodlands, Texas, 77380.
What is your current position with Ovintiv and how does it relate to the drilling unit and the Wyasket well?
I'm the manager of the Rockies land team with direct responsibility over this drilling unit, among others.
All right, would you please state for the record the corporate and bonding status of Ovintiv?
Yes, I mean, Ovintiv is fully bonded. I guess you're asking for, Ovintiv is a Delaware corporation in good standing with its principal place of business in Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor and name change to Newfield Production Company and by merger to Ovintiv Production Inc.
Great, thank you. Can you confirm for the record that exhibits 3 through 14 and 16 were prepared by you or by Ovintiv personnel or contractors with your review and input?
That's correct.
All right. Can you also confirm for the record that replacement exhibit 15 is an official business record of Ovintiv?
Yes.
All right. Would you also confirm for the record that you have read and can confirm all the statements made in your declaration are true and correct, or if any modifications are required, would you please state them at this time?
No, they are correct and no further modifications.
All right. Is it your expert opinion then, as a recognized expert in petroleum land management, that the terms and conditions of the joint operating agreement submitted as Exhibit 14 are fair and reasonable and consistent with those executed by Pool Creek Investments LLC covering the drilling unit and those commonly accepted by industry and in particular the Uinta Basin with respect to horizontal well operations.
Yes.
Mr. Rogers, that concludes my examination, Mr. Dale, and open him up for questions from the division and yourself.
Okay, division?
Yeah. Yeah, Peter Baker, the division. Just something really quick. We noticed again that there's a error in the API, but only in the testimonies, the proper testimonies.
In the declaration?
Declaration. Thank you.
Okay. And what's the change on it?
It's that you change.
Oh, so it should be it should be 47.
047.
Okay.
Right. Just like
All right, clarification for the record.
super simple. Yeah.
Thank you.
Welcome. That's it.
Yeah, other than that comment from our team staff, nothing from the division.
Okay, thank you. Okay, I just want to ask a question here. There's 4 parties to be compulsory pulled. One of them has to be a government agency, Uinta County.
Yes.
It's kind of what I've seen uncommon. Haven't know where they're at? Can't you get this statement from them or what they want to do?
Well, again, as Mr. Dale can answer that question as far as what they've indicated. They indicated they were going to lease, but it hasn't been done yet. And as far as the timing, again, they received the request for agency action and they received their notice of opportunity to participate. And other than indicating they would be willing to lease, they haven't done it yet.
And who makes that decision at the county? Maybe Mr. Dale knows.
I'm not entirely sure who has the authority. I mean, I would second Mr. McDonald's statement, which is yes, they have agreed to lease. It's not uncommon when dealing with any type of state or federal agencies that the process and empowerment of those groups to actually get something signed and completed in a timely manner often drags. So what I expect to happen is that we do get a signed lease with the Uinta County. However, in the event we don't, we're naming him here as to cover ourselves. But I do expect we'll have a lease signed with them in the coming months.
Okay. All right. I'm curious. Okay, thank you. We'll proceed with your net witness.
Great. Thank you, Mr. Rogers. Mr. Wall, would you please state your name and business for the record?
Christopher Wall, business address 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas 77380.
Well, what is your current position with Ovintiv and how does it relate to this drilling unit in the Wyasket well?
I'm a reservoir engineering advisor with jurisdiction over this GSU as well as others in the Uinta Basin for Ovintiv.
All right, would you confirm for the record that exhibits 17 through 19 were prepared by you or Ovintiv personnel with your review and input?
Yes.
Will you also confirm for the record that you've read and can confirm all the statements made in your declaration are true and correct? Or if any modifications are required, please state them on the record at this time.
They are true and correct, and I do not require any modifications at this time.
All right, is it your expert opinion then, as a recognized expert in petroleum engineering and reservoir engineering, this cost, that the actual costs of the Wyasket well reflected on Exhibit 17 were fair and reasonably and necessarily incurred, especially in light of the actual drilling and operational difficulties incurred as outlined on Exhibit 19?
Yes.
Also, your expert opinion that the Wyasket well was economically feasible to drill, as that term is utilized in the 139-134 order?
Yes.
Finally, on Exhibits 18 and 19, and particularly Exhibit 19, is it your expert opinion that they justify the imposition of a 300% risk assessment award, and is that fair and reasonable under these circumstances?
Yes.
Mr. Rogers, that concludes my examination. Mr. Wall, open them up for questions from the division and yourself.
Division?
Yeah, Peter Pankey, the division. If you could just go through some of these actual, just so we understand the timing and how everything happened. I'm just curious. Looks like there's a with this one.
Yeah, this one did encounter a few issues, and it's the way that it's listed out is in chronological order as well. So, you know, we set a 7-inch intermediate casing in this well, or attempted to. We're not able to get it all the way to bottom where we would like to have set it. So then we just set it a little bit short, cemented it, which isn't a terrible deal. It's not ideal, but it's not terrible. Then as we continue drilling, we parted our drill string. Not exactly sure how that happened, but it basically parted at a tool joint. Then sidetracking, the mud motor parted again on us, and then we ended up just setting, at that point, cutting our losses and setting our production casing short. And what happens when that happens is we lose lateral, we lose the ability to produce from the intended lateral length.
Yeah.
Can I ask right
that's a lot
here,
going on.
when something is parted, does that mean what's that mean?
So it depends on what parts, but casing can part or drill string can part, and it actually shears in half. In terms of the mud motor, that is what you have there is a rotor and a stator. I don't know if you're familiar with those terms, but basically it's a metal rod within a metal tube, and the rod inside is actually spinning, which actually causes the bit to spin for us. And those things sometimes do fail. That outer casing joint will shear and actually come apart. And so you're left with half a motor and a bit, and anything below that, that point in the hole.
Okay, so engineering term for it just broke.
Yep, it just broke.
Okay. Any more questions from the division?
Nothing.
Can we go back to the list of expenses? There we go. I notice on here, there's no consent decree, right?
Correct.
Now, how is Oventive allocating this? Is it geographic or timing, or how is that consent decree applied?
So this is where my knowledge of the consent decree is lacking. I'm not exactly sure how Oventive is allocating that fee or fine across the basin.
If I may, I read the Justice Department's press release, and it looks like it applied to certain facilities. So potentially this isn't a facility it applied to.
Okay, I just.
What I would suspect is it's the vending issues with the facilities, and they are tied to specific wells.
Okay, as I go. Okay, thank you.
And can I answer that? Jump in, Fred. We did, in fact, have a consent decree penalty on this well, but it just so happened that when we did the poll for the exhibits, call it 60 days ago, 45 days ago, we did not get that penalty included. I know Mr. Ellison had his on his exhibits, but both this Wyaska and the upcoming land wells were included in those penalties, but we failed to get those costs. So that's maybe something we can address before the board. I don't know what the appropriate way to handle it is, but it's not a huge sum of money.
If it would be your preference, Mr. Rogers, we can do a revised Exhibit 17 so that they can add those costs in.
I think the revision would
Okay.
be appropriate.
We'll file a revised exhibit with those costs in it.
And I can note that with that
Yes.
consent presentation. Okay. Yeah, Mr. Hall. Okay. All right. Now you've already had your questions for him,
Yep.
so at this time, are you concluded with your presentation?
That concludes our presentation, Chief. At this time, I would move for admission of Exhibits 1 through 14, Replacement Exhibit 15, Exhibits 16 through 19, and Exhibit 20 is supplemented, as well as Mr. Dale and Mr. Wall's declaration.
Division?
No objection.
No. Okay, so accepted.
Right, that concludes our presentation, Chief. I'll just reserve my comments for after the division statement.
Okay. The division filed a response of notice of non-opposition to the request for agency action dated November 12th, 2024. Therefore, it's my understanding the division has no objection to the request for agency action, but reserves the right to update its response after receipt of evidence and cross-examination. Is that accurate?
That's correct.
And give you some time to present your issues.
The division does not have a case in chief. We would also just appreciate a revised exhibit on this matter to address the penalty situation. Other than that, the division supports this request for agency action.
Okay. We'll take closing arguments at this time. Mr. McDonald?
Thank you, Mr. Rogers. Again, the statutory and regulatory requirements, we believe, have been satisfied. The request is, relief is fair, reasonable, and justified. And we would ask that you again recommend to the board that it approve the request for agency action as submitted. And again, thank you for your time, and thanks to the DNR staff for allowing the virtual appearances in this cause.
Okay. Does the division have any more?
Waive closing. Thank you.
Okay, thank you. Well, Mr. McDonald, we would like to move, we have moved for the admission of exhibits, so they've been admitted.
Thank you.
So I would say, having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find that offenders have provided sufficient notice of opportunity to non-consenting compulsory pooled owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geologic conditions present with this well, and find that it would be appropriate to impose a requested non-consent penalty. I find that the Ventive has met its burden of proof to show that they are entitled to forced pooling of the named interests and other relief requested in the request for agency action. Mr. McDonald, will you please prepare a proposed order?
I will, Mr. Rogers, and I will submit it to you and both the divisions and your council and the board's council prior to final submission.
I'll then will present the findings and conclusions to the board in our board training next month. Any other comments before we close?
None from the division.
Okay, thank you for your participation, and we will conclude this proceeding.
Thank you.
Hey, we're changing attorneys here, so anyone need a break? Thank you, Fred.
Thank you.
Yeah, sure. I don't plan on presenting anything necessarily, but you're right here. If you need to present, you can just share your screen, and that should be fine.
I'll wait for Colton to get back and get started. Okay, Matt, are we set?
There's that.
Okay. Mitch, you're good to go on everything?
Whenever you are.
Okay. Good morning. My name is John Rogers, and I am an environmental manager with the Utah Division of Oil, Gas, and Mining. I have been appointed by the Board of Oil, Gas, and Mining as a hearing examiner in this proceeding. Today is Wednesday, November 20th, 2024, and this is the time and place for the hearing examiner proceeding for docket number 2024-073, cause number 602-02. In a matter of request for agency action of Ovintiv USA Incorporated for an order pooling interests, including compulsory pooling of the interests of certain non-consenting owners in the Lamb, Utah 1-16 4-1-10-3-7H well, the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Formation, comprised of all sections 3 and 10, Township 4 South, Range 1 West, Uinta Special Meridian, Duchesne County, and Uinta County, Utah. We are holding this hearing with the anchor position in the Department of Natural Resource Building in Salt Lake City, Utah. We also will be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank all those who have allowed these proceedings to go forth both remotely and in person. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings? Seeing none in the room, I'll ask Matt, do we have anyone online?
No.
Okay, thank you. We have, let the record show that there are no members of the public here at this time. We'll take appearance of counsel at this time now. Petitioner?
Thank you, Mr. Rogers. Mitch Mayo, Lear PLLC, on behalf of the petitioner Ovintiv USA Inc.
Gordon Rowe, Assistant Attorney General for the division.
My counsel is Emily McKay of the Attorney General's Office. I've received declarations in this matter from Mr. David Dale, Manager, Rocky Land for Ovintiv USA Inc., and Mr. Christopher Wall, Reservoir Engineer Advisor for Ovintiv. I have reviewed both declarations before this hearing. Both these witnesses have been accepted as expert witnesses for past hearings. Does the division have any objection to these declarations or these individuals being qualified as expert witnesses?
No objection.
Okay. They are so recognized as expert witnesses in their particular field of study and work for this matter. Mr. Mayo, are these witnesses present, and can we swear them in at this time?
They are, Mr. Rogers, and that's perfectly appropriate.
Raise your right hands. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
Okay, thank you. We'll now proceed with Mr. Mayo for his presentation.
Thank you, Mr. Rogers. I appreciate the time on this matter. I was writing some notes. Did we admit them as experts?
Yes.
Okay, thank you. Pursuant to the board's order entered on October 15th, this cause was referred to the hearing examiner. Presuming the matter remained uncontested, I'd like to confirm on the record that is the case still today. As was noted, Mr. Dale and Mr. Wall both been recognized as experts in their respective fields, and both have submitted sworn declaration testimony outlining their written testimony for consideration at this hearing. As noted in the prior hearing, there will be one correction to Mr. Dale's, to the costs exhibit and to Mr. Wall's corresponding declaration, but we'll address that as we get into the testimony. The board and by designation, the hearing examiner have jurisdiction over this matter pursuant to Utah Code annotated 40-6-6.5 and the implementing regulations in 649-2-8A and -9A. This cause is a little unique in that there are no named parties to be pooled. There are only estates to be pooled, and there are only two of those estates. The estates that Ovintiv is seeking to pool in this cause are the estate of Cale R. Webster and the estate of Dwayne J. McGee. Pursuant to order of the board, entered on October 15th, Ovintiv provided notice of the request and this hearing to both the estate of Cale Webster and the estate of Dwayne McGee via publication in the Uinta Basin Standard and the Vernal Express. A copy of the REA was mailed out to all relevant federal and state and tribal agencies as required under Utah law based on the mineral ownership within the drilling unit. Notice of the filing of the REA and this hearing was duly published in the Salt Lake Tribune, the Uinta Basin Standard, and the Vernal Express on October 27th, October 30th, and the Salt Lake Tribune on October 27th, Uinta Basin Standard and the Vernal Express on October 30th, and the Deseret News on November 1st of 2024. On November 12th, the division filed their response and notice of non-opposition, essentially waiting for presentation of evidence here today at this hearing to make their determination. There were no other objections or responses to the REA timely filed, but I'd like to alert everyone that the notice by publication was effective. We did get contacted by one of the heirs of the estate of Cale Webster and confirmed that that set of heirs were leased. So to the extent that the division or the hearing examiner is concerned about the efficacy of notice by publication, I can confirm again in this matter it worked. To sum up, this cause involves compulsory pooling of a 1,290.52 acre drilling unit established for Lower Green River Wasatch Formation production and comprised of the entirety of sections 3 and 10, Township 4 South, Range 1 West, straddling Duchesne and Uinta counties border. This drilling unit was established by the board in orders 139-150, entered on February 23rd, 2018, which order was subsequently modified in November of 2020 in cause 600-03. Ovintiv is the majority interest owner as shown in Exhibit 8 and is stated in Mr. Dale's declaration. I'd also like to note that Mr. Dale was not originally identified as the witness in this cause, but due to scheduling concerns and witness testimony, Mr. Dale's resume was submitted as a part of a replacement Exhibit 1. Pursuant to the current orders, the two current spacing orders on file is Exhibit 2, Ovintiv spud and has begun to produce from the Lamb UT 1-16, 4-1-10, 3-7H well. The subject well was spud on February 9th, 2021 and began producing on May 27th, 2021. At the time the request was filed, there was one well producing from the subject lands, the Lamb 13-10-4-1 well. This will be called the existing well, a vertical well, which was drilled to and producing from the southwest of subject section 10. Accordingly, conversion, as provided for in the 139-150 order, occurred on June 1st, 2021. Although Ovintiv does not believe there is any recoupment due and owing relative to the existing well, Ovintiv hereby confirms that it waives any further recoupment due related to the existing well, if any. As noted earlier, there are only two estates to be pooled, the estate of Cale Webster and the estate of Dwayne McGee. Although Ovintiv is confident that it has leased all successors, it can't be certain of that fact, and both estates are being maintained to be pooled solely as protection. Pursuant to the board's order entered on October 11th, the notice of opportunity to participate was provided to each of these estates by publication. And proof of that publication is on file as Exhibit 18 in this cause. No responses other than the phone call discussed earlier were received, and there are no corrections of note. Both estates will be pooled here today. Finally, as reflected on Exhibit 12 and discussed in Mr. Dale's declaration, the average weighted fee landowner's royalty in the subject well is 12.904647%. The costs, including the plugging costs, are just and reasonable, and the risks incurred in drilling the subject well justify the imposition of the risk compensation award requested. With that, I'll begin with my testimony with Mr. Dale. Mr. Dale, state your name and business address for the record.
Yes, David Dale, business address of 4 Waterway Square Place, Suite 100, Woodlands, Texas, 77380.
Thank you for that. And can you please state your position with Ovintiv and your responsibilities as they relate to this drilling unit?
Yes, I'm manager for Rocky's Land with direct and supervisory responsibility over this drilling unit, among others.
Okay. Mr. Dale, are you aware of the declaration that's been filed as Exhibit 16 in this cause, the declaration of David Dale testimonial?
Yes.
Okay. Have you reviewed that declaration exhibit?
Yes.
And are you familiar with all the allegations contained therein?
Yes.
Did you execute the declaration or cause your counsel to execute it on your behalf?
I did. Yes.
And does the declaration constitute your full and accurate testimony here at this hearing today?
Yes.
So there are no modifications necessary?
No.
Okay. Finally, as a recognized expert in petroleum land management, is it your opinion that the terms and conditions of the JOA on file as Exhibit 11 are fair, reasonable, and consistent with those commonly accepted and used in the Uinta Basin?
Yes.
With that, I have no further questions for Mr. Dale, pending division of hearings and imminent questions.
Questions?
Just a curiosity, the average weighted royalty for the lands is just shy of 13%, which is less than some of the others we've seen today. Is that due to the JOAs involved in this area?
No, if you pull the exhibit, the vintage of a lot of those leases were from 2004 up until, I guess, some in 2020. So I think just the sheer nature of older leases with lower royalty rates have dragged that average down to a lower amount.
Great. That's all I had for you guys. I have nothing else from the division.
Thank you. I'd like to go back to the existing well. Was that a vertical well?
I believe it was. Yes.
Okay, so how is the conversion done on that then? I assume there was a spacing order at that time for that well, or was it drilled?
I don't know definitively if there was a spacing order for that well. I don't believe there was. I think it was drilled under the default regulations, but please don't hold me to that.
Okay, well, that's not critical really, but I'm just wondering, how is it converted then?
So under the 139-150 order, and I'll answer this first, David, because I think it's technically a legal question. Feel free to hop in if I misstate something. Under the 139-150 order, the board ordered that all existing wells convert to the new, in this circumstance, 2-section drilling unit basis upon completion and production of that first 2-mile well. And so the 139-150 order is what controls, and it says the first day of the month following the date of first production. That shall convert. So that existing well, that Lamb vertical well that was drilled in the southwest of 10, upon production from this current well that the hearing examiner is considering, the 139-150 order by its operation automatically converts that existing well to being payable on a 1288 basis. So it's not the spacing order for the existing well, it's the spacing order for the future wells that governs that.
So the existing vertical well production of that goes to the new unit?
That's right.
Okay.
That's right.
Take this one.
Anything to add to that, Mr. Dale, or anything I misspoke about?
Nope.
Okay,
Ovintiv is the operator of that well?
that's correct.
We are, yes.
I have a question. You mentioned that in you had a response from the heirs of Cale Webster from publication, but they aren't leased. Did you?
They are.
They are now leased.
Well,
okay.
some of the heirs.
Some of the
reached out
heirs
to us.
are.
We
okay.
don't know who all the heirs are because the court hasn't told us.
Okay, got it.
But to be clearer, it was Cale Webster's daughter has since passed away.
Okay.
And it was Cale Webster's granddaughter who contacted me to clarify. So there's a couple issues in the estates, but it was clear that they are some type of heir to some share of Cale Webster's estate, and all of the folks that called us, we confirmed they're leased.
Okay.
So
thank you.
On her line of questioning, so they leased, but there's other heirs that have not leased. How do you divide that up?
I can't say that definitively. I can say that, you know, and David, maybe you can address how you guys handle this in situations where you've got an heir and you think everyone's leased, but not. How do you handle payment?
Well, I mean, I think that really just points to the fact of why we're pooling it, right? We have a probate. out of state. We have some heirs that have leased, some heirs that have not. And without it being probated in the state of Utah, we don't have marketable title. So we cannot distribute royalties until they get that resolved. However, it does clean up that Oventive does in fact have 100% of the working interest rights associated with that interest. Now, we will mail division orders and work with those owners to try to guide them to get it properly probated so they can in fact be put in pay.
Okay, so there will be no dollars, even though this individual lease, there'll be no dollars given to them until it's all cleared up.
That's correct. They do not have marketable title.
Okay, no more questions from me.
Okay. With that, Mr. Dale, hang on tight. You're good for now, but we may have a roundup question for you at the end here. Mr. Wall, are you available?
Yes, sir.
Could you please, the board knows who, or the hearing examiner knows who you are by now. Could you please state your name and business address for the record in this cause?
Yes. Name is Christopher Wall. Business address 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas 77380.
Okay. And one last time, your job title and responsibilities as they relate to this unit.
I'm a reservoir engineering advisor with jurisdiction over this DSU as well as others in the Uinta Basin for Oventive.
Okay. Now, Mr. Wall, are you aware of, and you've seen what's been filed as Exhibit 17 in this cause, the declaration of Christopher Wall testimonial?
Yes.
Have you reviewed that exhibit in its entirety?
Yes.
Okay. Did you execute or cause your counsel to execute that declaration on your behalf?
Yes.
Okay. Do you agree with, or can you confirm the truth and accuracy of the allegations contained in the declaration?
Yes.
Okay. Does the declaration represent your full and complete testimony here today?
Yes.
Okay. Before I make you commit to the accuracy of that declaration, I'd like to reiterate to everyone that we've noted at the outset there will be a correction to the declaration based on the costs exhibit that will include the consent decree. Does that match your understanding that essentially the declaration is accurate, but for the correction of that costs exhibit that was mentioned at the outset?
Yes, that's correct. We would like to add the consent decree associated with the LAM 7H to Exhibit 9, which covers the well costs.
Okay. Perfect. Is there anything else you need to add or clarify or modify about your testimony before we move on?
Not at this time.
Okay. As a recognized expert in petroleum engineering, is it your opinion that the actual cost of the subject well, including what you anticipate to be the consent decree portion costs, were fair, reasonable, and necessarily incurred?
Yes.
Do you believe those costs are within a reasonable variance of the estimated costs as outlined in the AFE and Exhibit 9?
Yes.
Okay. Do you believe the subject well, the LAM 7H, was economic to drill, as that term is utilized in the 139-150 order?
Yes.
And the risks identified in Exhibit 15, as discussed in paragraph 9 of your declaration, do you believe those justify the imposition of a 300% risk compensation award?
Yes.
Okay. With nothing else, I have no further questions for Mr. Wall pending questioning from the division and hearing examiner.
Division?
No questions for this witness.
Okay.
I have a follow-up question for Dale. Just if that was an okay time.
Sure, yeah.
Okay. I was looking at your declaration and it says that Cale Webster State was, did go through probate in Texas in 1981. And that you require some sort of Utah court order to distribute that estate. Is that the norm? If in fact all the heirs have been established by a Texas court, that's just
The law, and I guess I can speak to this, Mr. Dale, the law is that the probate has to be done where the property is located.
Okay.
And so his estate has been probated under Texas's laws and will distribute any of Texas assets,
Okay.
but wouldn't have the same effect. Now, it's a pretty simple process, as I understand it, to have that judgment essentially converted to a Utah judgment or recognized by a Utah court, but that hasn't been done. And as was said, it's been about 40 years since then, and his survivor, who we believe to be his survivor, passed as well with no probate of her estate. So it's not simply a question of which one's applicable, but yes,
Okay, that makes sense.
it has to be done. Often we have probates, and that's where we get information for how to track down heirs
Right.
in other states.
Okay.
So having that done in Texas, it may be actually a little easier. I mean, because you've identified them and it makes it easier for them to
It should
move
be,
forward.
it should be easier.
But that's
Just to add a little bit, the reality is every company takes their own risk profile to how clean or marketable the title is. When you have an estate that has been probated, not within the state or the county that it's located in, typically a lot of those companies will move forward with the distribution of royalties just because it's a pretty low risk. So that is the reality, but we still do in fact want to pool them to give us certainty as to the working interest side.
Okay, that makes sense.
okay. Thank you. That's interesting to know. That's
Yeah.
So, okay, we'll move forward. Any more witnesses? And
No, with that, I think I'm done with both witnesses, and I'll simply reserve my final comments till the division presents.
okay, I think it was noted earlier that the division had filed a response of notice of non-opposition to the request for agency action on November 12th, 2024. So it's my understanding that the division had no objection to the request for agency action, but reserves the right to update its response after receipt of evidence and cross-examination. So noting that, we'll turn the time over to the division.
The division will renew its non-opposition and waive its case in chief and just voice our appreciation of petitioners' explanation of any of the issues we brought up today. That's all we have.
Okay, thank you. We'll take closing statements at this time from the division and the petitioner, and we'll start with omitted. Mr. Mayo.
Yes, before I start my closing, it's probably appropriate to move for admission of exhibits. I'd like to move for admission of exhibits 1 through 11. 1 through 12. What will be submitted as revised exhibit 11 to make the correction to the consent decree costs. Exhibits 14 through 16 and the slightly revised exhibit 17, Mr. Wall's declaration corresponding to those costs, and also move for admission of exhibit 18. Exhibits 1 through 18, exhibits 13 and 17 will be revised.
I do not have a record of the replacement exhibit 1 as stated as being filed on November 8th.
Oh.
The declaration of David Dale.
Okay. I can forward the email to you after this if you'd like.
Okay.
But I guess it's probably appropriate to move for admission of revised exhibit 1 or Dale's
Okay.
Replacement exhibit 1.
replacement. Yeah.
Division, do you have any?
No objection.
Okay. I have no objection to those, and so we'll accept those exhibits as stated.
In close, briefly, it's our position that all regulatory and statutory requirements have been met, that both the states have been provided adequate and lawful notice, and both have been alerted to this hearing. None responded. On that basis alone, we'd ask that the hearing examiner approve the request as pleaded.
Anything for the division to add?
We'll waive closing. Thank you.
Mr. Mayo, would you, we've already moved for admission, haven't we? So let's just say, having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find that Ovintives have provided sufficient notice of opportunity to the non-consenting compulsory pooled owners, and that those owners identify in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geological conditions present with this well and find it would be appropriate to impose the requested non-consent penalty. I find Ovintiv has met its burden of proof to show that they are entitled to forthcoming of the named interest and other relief requested in the request for agency action. Mr. Mayo, would you please prepare a proposed order?
I'm happy to.
Okay, I then will present the findings and conclusions at the board hearing next month. Any other comments before we close? Okay, thank you for your participation, and we'll adjourn this proceeding at this time. Thank you.
Thank you.